The Honourable Minister of Citizenship is rising on a point of order.
No. I'm waiting for debate.
We are resuming debate. If the Honourable Minister would like to debate, he will require the unanimous consent of the House to do so. The Honourable Minister of Citizenship.
Mr. Speaker, I would. Unfortunately, I was unable to speak at the beginning of the debate because I had a meeting with the Foreign Secretary of the United Kingdom, which could only take place an hour ago. So I beg the indulgence of the House to seek unanimous consent to permit me, as the Minister moving the bill, to speak at this point.
Does the Honourable Minister have unanimous consent to speak at this time? Yes, agreed. The Honourable Minister of Citizenship and Immigration.
Thank you, Mr. Speaker, and I appreciate the indulgence of the House. As members will know, I make a point of attending all of the debate on bills for which I am responsible, and I take the importance of ministerial presence in these debates very seriously, and I appreciate the indulgence of the House in this respect. Monsieur le Président, le projet de loi C-43 est une mesure importante pour renforcer l'intégrité du système d'immigration au Canada. Nous l'appelons la loi accélérant le renvoi des criminels étrangers. Évidemment, Monsieur le Président, le Canada est un pays accueillant envers les nouveaux arrivants de partout au monde. Effectivement, depuis l'arrivée au pouvoir de ce gouvernement, on a accepté le plus grand nombre d'immigrants dans l'histoire du Canada, plus de quart de million par année. Ça veut dire une augmentation de 14% par rapport aux niveaux d'immigration du gouvernement libéral précédent. En même temps, on a gardé le niveau d'immigration per capita le plus important au monde développé. Ça veut dire que nous ajoutons à peu près 0,8% de notre population par immigration chaque année. En même temps, nous augmentons le nombre des réfugiés réétablis qui nous acceptons par 20%. On va augmenter à plus de 14 000 le nombre des réfugiés de convention qui nous invitons de venir ici s'installer au Canada pour avoir le niveau de rétablissement des réfugiés le plus élevé au monde. Et en même temps, Monsieur le Président, ce gouvernement a triplé les fonds d'investissement les fonds pour l'intégration, les services d'établissement pour les nouveaux arrivants. Et on a fait tellement pour aider l'intégration et le succès des nouveaux arrivants. Et Monsieur le Président, quand je travaille de près avec les nouveaux arrivants au Canada, je les écoute quand ils disent qu'ils veulent un système d'immigration bien cadré dans nos lois justes et équitables. Ça veut dire qu'ils veulent un système d'immigration qui est basé sur la règle du droit. Il ne veut pas permettre ceux et celles qui posent une menace à la sécurité de nos collectivités de venir ici ou de rester ici. Il veut un système qui est accueillant avec les nouveaux arrivants de partout au monde, qui veulent venir ici, respecter nos lois, bâtir le Canada, contribuer leurs impôts et respecter le Canada. Mais les nouveaux Canadiens n'ont aucune patience pour ceux et celles qui viennent ici pour abuser la générosité du Canada et des Canadiens. And that's what I hear from new Canadians all around the country, Mr. Speaker, that they and all Canadians, whether born here or newly arrived, treasure our country's historic posture of openness to the hard work and talents of newcomers, including refugees from persecution. At the same time, Canadians, especially those who came to this country from abroad, have no patience for those who would violate our laws or abuse our country's generosity. And that is why we have brought forward Bill C-43, the Faster Removal of Foreign Criminals Act, which seeks to make several amendments to the Immigration, Refugee and Protection Act, designed on the one hand to facilitate and make, frankly, easier the entry into Canada of legitimate visitors and immigrants, and on the other hand, which seeks to give us stronger legal tools to bar from Canada those who may pose a risk to this country and to remove from Canada those who have committed serious crimes and been convicted of such by our fair judicial system. So allow me, Mr. Speaker, to review the provisions of the Act. First of all, with respect to facilitating the admission of bona fide visitors and immigrants, the bill seeks to narrow the breadth of the inadmissibility provision for espionage to focus on activities carried out against Canada or that are contrary to the interests of Canada. So right now, under Section 34 of the Immigration Refugee Protection Act, anyone who is or has belonged to an organization that is or has been involved in espionage is prima facie inadmissible to Canada. But quite frankly, this has the effect of covering those who may have been involved in espionage for close democratic allies of Canada who may in fact have been gathering intelligence on behalf of Canada against common security threats. And so we believe that this wording in the Immigration Act is unnecessarily broad, and that we ought to focus the inadmissibility provision with respect to espionage on those who have been engaged in spying contrary to the interests of Canada. Secondly, the bill would permit the temporary entry of individuals with an inadmissible family member, except where the family member is inadmissible for security, human or international rights violations, or organized criminality. So this is to say, for example, Mr. Speaker, that imagine a family has applied to visit Canada, but it turns out that one member of the family is medically inadmissible. That is to say, they, according to officials, would represent, and according to a medical exam, may pose a excessive burden to Canada's taxpayer-funded public health system. In that case, under the current law, the entire family, all members, would be rendered inadmissible because they're considered as a package, as it were. This amendment would allow us to sever the one inadmissible person from that group so that the other family members could still be admissible to Canada, and this is a measure that has been broadly supported by immigration practitioners and others who see the unnecessary breadth of the current law. Thirdly, the bill provides express authority for the Minister of Public Safety to grant ministerial relief on the minister's own initiative. This is to say, Mr. Speaker, that if our legal system, let's say the Canada Border Services Agency, which is delegated by me under the Immigration Act, finds that someone is inadmissible, there is a process, a lengthy, time-consuming process to seek relief from the minister. This clarifies that the minister could take that initiative, streamlining the relief process for legitimate and bona fide visitors or immigrants. Donc, permettez-moi de passer aux mesures du projet de loi qui va renforcer l'intégrité du système et protéger la sécurité des Canadiens. Tout d'abord, le projet de loi créera une nouvelle autorité pour le ministre de Citoyenneté et Immigration à rejeter le statut de résident temporaire pour les étrangers sur la base des considérations des politiques publiques pour une période de jusqu'à 3 ans. So this would allow the Minister of Immigration on public policy grounds to deny admission to Canada for up to 3 years of a foreign national who otherwise may be admissible. Now this is a very delicate part, very delicate proposal that we are making, Mr. Speaker, and I really do hope that the Standing Committee on Citizenship and Immigration will focus on this particular proposal to help guide, frankly, myself and the government as to how we can construct criteria, either by ministerial order or published regulations, or perhaps even an amendment to the bill itself, which would help us address, let me call them really exceptional or extraordinary circumstances, where, now under the current law, Mr. Speaker, a foreign national is typically inadmissible only if they have a criminal record in a foreign country that would also be a serious crime in Canada. So that obviously excludes political prisoners because those, so-called political crimes, trumped-up charges are not a crime in Canada. Or if they are or have been a member of a criminal organization, a banned terrorist group, as I mentioned before, have been involved in espionage, or may pose a serious security risk to Canada. Or then, of course, if they're medically inadmissible in some other categories. Now, Mr. Speaker, here's the problem. From time to time, we get people seeking admission to Canada who may not have a criminal record abroad, but they may actually be coming here to incite hatred and violence or incite terrorism. Je vous donne l'exemple l'année dernière d'un ressortissant, je crois, de Royaume-Uni, qui s'appelait Abdurrahim Green et Hamza Tsotis, qui voulaient venir au Canada, effectivement, qui sont venus au Canada, mais qui avaient un bilan épouvantable de la promotion de haine contre les femmes, les homosexuels, les gays et lesbiens, les juifs et certaines autres minorités. Et plusieurs Canadiens avaient peur que ces hommes-là avaient l'intention de venir ici au Canada pour promouvoir la haine, la violence et même peut-être le terrorisme. Mais dans la loi actuelle, on n'a pas la capacité d'interdire l'entrée au Canada d'une telle personne. Parce que, par exemple, je peux vous dire, il y a certains pays au monde où, évidemment, ce n'est pas un crime à promouvoir la haine contre les juifs ou les homosexuels. Et donc, peut-être, ce que nous proposons dans le projet de loi est de donner au ministre un pouvoir, oui, discrétionnaire, mais bien avec les balises pour interdire au Canada certains étrangers qui ont l'intention à promouvoir la violence, mais pour qui ce n'est pas un crime dans leur pays d'origine. Donc c'est quelque chose qu'il faut avoir, d'aller plus loin, d'aller plus profondément dans une étude de cette section du projet de loi au comité permanent. Secondly, Mr. Speaker, the bill seeks to lower the current threshold to bar access to the Immigration Appeal Division for serious criminality from a minimum sentence requirement of 2 years to a sentence of 6 months, and also bar those who were convicted of an offense or committed an act outside Canada, which, if committed in Canada, would carry a maximum sentence of at least 10 years. And this, perhaps, is, colleagues, the most important element of the bill. Now, let me explain, because the perpetually angry member from Winnipeg North who just spoke, and sadly misinformed Liberal critic in immigration, was outraged with the suggestion that we should deport foreigners in Canada who are convicted by Canadian courts of a serious crime, punished, and are given a sentence of 6 months or more. Mr. Speaker, apparently and regrettably, the Liberal critic is not aware of even the basics of the current immigration law, because the Immigration and Refugee Protection Act, adopted in 2002, when his party was in government, says that if a foreign national is convicted of a crime with a sentence of 6 months or more, they are subject to deportation. That's what the current law says. But here's the problem, Mr. Speaker. Because the Liberals were more concerned about the procedural rights of criminals than public safety, they allowed for a loophole, which was that if you were convicted of a crime of 6 months or more as a foreign national, yes, you'd be subject to deportation. But if the sentence was 2 years or less, so somewhere between 6 months and 2 years, you could appeal the deportation order from to the Immigration Appeal Division. So how does this work? So a foreign national, I've got a case here, rapes a Canadian senior citizen. And Cesar Guzman, convicted of sexual assault of a senior citizen. His sentence, 18 months of jail. He managed to delay his deportation for 4 years, meaning this man who sexually assaulted a Canadian senior, this foreigner, was walking our streets posing a risk to other Canadians. Why? Because he went after his conviction he would have gone to the Immigration Division of the Immigration Refugee Board. They would have ordered his deportation pursuant to the current provisions in IRPA. But then he would have used the Liberal delay tactic. He would have appealed that deportation order to the Immigration Appeal Division. And I don't have his whole chrono here, but I'm sure, because I've seen this hundreds of times, he would have lost at the Immigration Appeal Division, and then appealed that to the federal court. And if, like some of these other characters that we've seen, he was really aggressive, he would have appealed that negative decision to the federal court of appeal. You add up each of these appeals, and what does it mean in concrete, real-world terms? It means violent foreign criminals convicted by Canadian courts of law walking our streets when they should no longer be in Canada because they lost the privilege of being here, Mr. Speaker. And that's the point that this member does not seem to understand. To be a foreign national in Canada, whether as a visitor or as a permanent resident, is a privilege, and it's not a hard one to keep. All that we ask of you are two things: that if you want to maintain your permanent residency, you live here for 2 out of 5 years, and secondly, that you not commit a serious crime.
There you go.
Now, Mr. Speaker, the vast majority of new Canadians will never commit a serious crime, and they therefore have no tolerance for the small minority that do, who have lost the privilege to stay in Canada. And Mr. Speaker, I agree, because I am as committed to as any member of this House to due process and natural justice and the rule of law. I agree that even serious convicted foreign criminals should get their day in court. I agree that they should benefit from due process. I agree that they should not be deported without consideration by the Immigration and Refugee Board. But I do not agree that they should get endless years in court and be able to abuse our fair process. Mr. Speaker, with this bill, we put an end to that abuse. We have cases like in my own hometown of Calgary, Mr. Speaker. Calgarians, especially in the Vietnamese community, were outraged. I hear he's laughing, Mr. Speaker. The member for Winnipeg North is laughing.
Point of order, the honourable member from Winnipeg North.
Mr. Speaker, on a point of order, I was sitting in my chair listening to what the minister was saying. It was his colleague, another minister of his, that was actually laughing, not me, Mr. Speaker.
The honourable minister.
That's true, actually. He's always so angry, he never laughs. Mr. Speaker, Mr. Speaker, Jackie Tran was running a youth drug gang in Calgary that was terrorizing the Vietnamese community, that his gang was involved in multiple murders. He always avoided getting caught on murder, but he got caught and prosecuted and sentenced on several offenses like assault with a weapon, drug trafficking, drug possession, failure to comply with court orders. But it took us 6 years to remove him from Canada because on every one of these charges, which under the law ought to have led to his deportation, he used the endless and redundant appeals to delay his deportation for up to 6 years. So this guy, who was running gunmen around Calgary, whose gang was responsible for slaughtering people on our streets, was able to stay here for 6 years. Now, you know, Mr. Speaker, I'll admit that there's probably one provision of this bill that Canadians don't support, and it pains me to admit. But I suspect the vast majority of Canadians would say this bill is far too lenient. That in fact, for Jackie Tran, the moment he is convicted, there shouldn't even be a consideration of his deportation after he pays some time behind bars in Canada. That people like him, most Canadians would say, should be sent packing immediately, but we at least will give them a hearing before the IRB. Oh, but what's the opposition's attitude? Keep the loophole. Permit the endless delays. Let Jackie Tran stay here and terrorize our Vietnamese community for 6 years. On behalf of the law-abiding members of Calgary's Vietnamese community, I say the Liberals are wrong, that we should deport criminals like this, Mr. Speaker. And I mentioned Cesar Guzman. What about Mr. Jayachandran Balasubramaniam? He was charged and convicted of assault with a weapon, drug possession, drug trafficking, and failure to comply with court orders, 18-month sentence. This is not getting involved in a minor traffic accident. This is not a minor traffic accident. Delayed his deportation for 7 years. And Mr. Speaker, most terribly, the case of Clinton Gale, a repeat violent foreign offender who delayed his deportation for years. Yes, there were operational screw-ups on his removal, but had this law been in place, he would have been removed before he could kill Toronto Police Constable Todd Bayless. Mr. Speaker, we owe it to people like the family of Todd Bayless and all of these other victims to pass this law, which is what the Canadian Police Association has called upon us to do. It's what the Canadian Association of Chiefs of Police have called on us to do. It's what victims of violence have called on us to do. And Mr. Speaker, I will listen to the victims of crime before the Liberals and the NDP when it comes to public safety.
For questions and comments, the Honourable Member for Newton North Delta.
Thank you, Mr. Speaker, and I want to thank my colleague, the Minister, for his very impassioned ending to his speech today. And I want to say that as the official opposition, the NDP recognises the need for an efficient and responsive judicial apparatus for removing serious criminals who are not citizens. But we have to remember, it kind of sticks in my throat when we keep calling them foreigners, because these are the people who we've admitted into the country, and they are permanent residents. They have not gained their citizenship. We absolutely agree that we need to address the loopholes. However, we believe that this bill goes far too far, so to speak, and there's one part of the bill that is rather kind of, I would say, sticks in my throat, so to speak. This new law relieves the minister, and I find the word relief in there interesting, relieves the minister of the obligation to consider humanitarian and compassionate considerations at the request of a permanent resident. They call a foreign national. Is this the kind of Canada we want? Why would the government want to relieve the minister of considering the best interest of children in possible deportation cases?
The Honourable Minister of Immigration.
Thank the member for her question. To be clear, Mr. Speaker, the bill proposes to eliminate access to the humanitarian compassionate process, not for those facing deportation in general, but for those facing deportation on the grounds of security, human or international rights violations, or organized criminality. Now, that is to say, I guess this is a fundamental philosophical difference. The NDP believes that convicted members of criminal gangs who are foreign citizens should be able to get special consideration to stay in Canada permanently on humanitarian grounds, or that people who have been, for example, according to the IRB, have been found complicit in war crimes in their country of origin should be able to I would submit, abuse our process by making an application for permanent residency on compassionate grounds. Mr. Speaker, I believe Canadians are hard-hearted. Hard-headed, but soft-hearted. We are compassionate. We are compassionate, but we are hard-headed when it comes to foreign criminals, but soft-hearted when it comes to legitimate cases of humanitarian and compassionate consideration. I do not believe that a foreign gang member or a terrorist or someone who's been found complicit in war crimes should get access to our humanitarian and compassionate process. It's an abusive process.
Questions and comments, the Honourable Member for Winnipeg North.
Yes, Mr. Speaker. My question to the Minister is he refers to the top 5 reasons for faster removal, for the justification of this legislation. And he always makes reference to Jack Tran. He takes that extreme element. And I would suggest to you, Mr. Speaker, that there's no one inside the House of Commons that justified or wanted to see Jack Chan or these 5 individuals that he includes in his press release stick around in Canada. In fact, one could be critical that why did it take you so many years in order to try to be able to deal with the issue? The problem is that you get this extreme attitude, Mr. Speaker, that this minister fosters. And we saw it today in the backbenches of the Conservatives. And let me pose this in the form of a question. What about the permanent resident, because that's really what it's all about, permanent resident. If a permanent resident that's been in Canada for 15 years goes to an event and drinks past 0.05, maybe he's 0.06, and he's criminally found to be drinking and driving, should that individual be deported? According to the Conservatives, or minds of Conservatives, he should, because he's a criminal, because he got a criminal conviction. What is the Minister of Immigration's opinion on that?
The Honourable Minister of Immigration.
Once again, it's clear that the member does not understand the current law, does not understand the bill, The current law says that according to the Immigration Refugee Protection Act, a foreign national, this is not selective, this is just cold and hard facts, that a foreign national, in common parlance, a foreigner, who is convicted of a Canadian court to a crime of 6 months or more is a serious criminal, and that following such a conviction, he or she is subject to removal from Canada. The only question is whether or not he gets years of appeals on that deportation. Now, Mr. Speaker, we're very careful, actually, in focusing on the maintaining the 6-month bar that already exists in IRPA, because that will not involve, if someone goes to a bar and they have a bad night and they get into a fight, they're not going to be affected by this. If someone's convicted of shoplifting, they're not going to be deported. If someone has a minor fraud count, check cutting or something, they're not going to be, if they have a minor traffic offense, they're not going to get a penal sentence of 6 months or more. These are for people involved in things like drug trafficking, sexual assault, possession of a dangerous weapon, multiple assaults. Mr. Speaker, these are the cases we are talking about. These are serious crimes according to the law and according to our courts, and they should have serious consequences.
Questions and comments? The Honourable Member for York South Weston.
The Minister has suggested that it's serious crimes that should create the burden, I guess, for the government to evict an individual and to kick that person out. There are a number of people in this country who would rather that Lord Black of Cross Harbour was not here. Would this change in this law affect his status in any way?
The Honourable Minister of Citizenship.
Mr. Speaker, the IRPA deals, and this bill deals with those foreign nationals who have committed crimes in Canada. If he has evidence of anyone who has committed a crime in Canada for which they've been sentenced to a period of 6 months or more, he ought to bring that forward to the relevant police authorities.
Questions and comments? The Honourable Member for Kildonan St. Paul.
Thank you, Mr. Speaker. And I would like to ask the Minister a question, because I've been listening to all these arguments, and the member from across the way from Winnipeg North was very concerned about someone who might have a drinking and driving problem. Now, it's my interpretation of what was said this morning that we're talking about people who have very serious infractions, people who actually do serious harm against Canadians, against people in our country. Will the Minister please explain why this can't be understood by members opposite to relieve their minds that the ordinary citizen won't be deported quickly?
The Honourable Minister of Citizenship.
Mr. Speaker, I don't understand the contention of the member for Winnipeg North. I'm not aware of anyone in Canada who's ever been sentenced to a 6-month prison sentence for a charge on driving under the influence. Perhaps if it's their 10th or 15th DUI conviction, perhaps if they ran into someone and their driving under the influence resulted in manslaughter, they would be affected by this provision. But anyone who I'm not, and I challenge the member, if he can come up with a single case of anyone who's gotten a 6-month custodial sentence for simple driving under the influence, I challenge him to bring that forward. He is trying to he's trying to distract the fact us from the fact that this deals with what the law calls serious crimes like assault, like sexual assault, like serious drug trafficking, and these sorts of offences, including quite frankly, in the case of Clinton Gale, somebody who had multiple firearms offences was allowed to stay in Canada using these delay tactics that we are now removing, who went on to kill a Toronto police constable. I don't think that we have any obligation to allow a permanent resident like that to stay in Canada once he's already benefited from due process.